Hiya, welcome onto the webinar today. Thanks for joining us. I'm Camille Breward. I'm Senior Marketing Executive here at myhrtoolkit, and I'd like to welcome you to today's webinar. So for those of you who are new to us, myhrtoolkit provides HR software for SMEs, and we run an ongoing program of webinars covering a variety of HR and business topics. Just before we go on to today's topic, which I'm sure you're all eager to hear about, I wanted to mention our next upcoming webinar, which is on February, Wednesday the 23rd, and it's all about the Great Resignation and how small businesses can respond to this and retain their staff. So if anyone's interested in signing up for our next webinar, I'm just going to pop a link to that in the chat, which should take you through to the registration page in case that is of interest to you. But without further ado, for today's webinar, we're going to look at the somewhat controversial and quite recently newsworthy topic of whether employers can stop sick pay for unvaccinated employees who are isolating. So what could be the potential legal and HR implications of this move that companies like Ikea and Next have recently made? So during this webinar, we'll be having a look at the potential legal ramifications of treating vaccinated and unvaccinated employees differently in the workplace, the differences between company and statutory sick pay in that regard, making changes to company sick pay policy, and avoiding direct and indirect discrimination in the process. Following the presentation, which will last around 30 minutes, we'll also have time to answer some of your questions in a Q&A. So if you have a look on your menu on Zoom, you should see that there is a specific Q&A option. And that's the place to ask your questions for the Q&A after the presentation. Do also get involved in the chat as well. But if you do have a specific question for our guest today, make sure to ask that in the Q&A. Just as a little caveat, today's session is offering sort of general information and not legal advice. So here to talk to us this morning about vaccination status and sick pay is Charlotte Geesin from Howarths. Charlotte is a legal director for Howarths, who are an award-winning family business providing specialist HR and employment law advice and support to other businesses. After qualifying as a solicitor in 2011, Charlotte has specialised in providing employment law advice to the SME market ever since. And in 2019, she also became qualified to practice immigration law and now supports businesses with their immigration requirements. So Charlotte, really great to have you with us today. Thank you.
Oh, thank you for having me. I'm really pleased to be here.
No worries. And I will hide off camera for a bit now and let you get on with your presenting.
Thank you. So good morning, everybody. I hope you're all okay out there in the ether. As Camille said, over the course of the next 30 minutes or so, I will be looking at the current legal position in respect of vaccination, specifically the COVID-19 vaccination and sick pay. We have quite a lot of ground to cover this morning, and as you'll probably already have worked out, it's not the most straightforward of topics. That said, I'm very happy to take questions during the session or to accept any feedback, any comments that you might have on the issue generally, any rants that you might want to make. It's a ranty subject at times, so if you want to either pop any questions, comments into the chat box or the Q&A box, I will do my very best to answer them. There is a section designated at the end of the presentation for Q&A, so if you'd prefer to wait until then, absolutely fine, but if you're anything like me, if you think you may forget what your question was by the end of the session, then like I say, by all means pop it in either the Q&A or the chat box as we go, and I'll pick up on it as soon as I'm able to. Right, okay then, so without further ado, in terms of the session today, some key learning objectives. I hope that by the end of things today, you'll have an awareness of the following: the difference between statutory and company sick pay. It's very relevant because the rules relating to the different types of pay are different. The legal position in respect of statutory sick pay in the context of isolation and contracting COVID-19, The legal position on company sick pay in respect of the same. What employers should consider if they want to make company sick pay contingent on being vaccinated. So that's what your likes of Ikea, Wessex Water have recently done, and some discrimination risks. I'm going to start off by addressing some key questions around the right to pay in certain situations relating to vaccine status. I think that's probably the easiest way to kind of structure today, because hopefully it will put the sort of legal advice into some sort of definitive context for you. Before we get on to those sort of key question areas though, I'm just going to give a quick overview on statutory versus company sick pay. So it goes without saying that in the UK we run a statutory sick pay scheme which sees eligible employees receive £96.35 a week if they are too ill to work. That payment is funded by the employer. It didn't used to be, but it is now, and it's payable for up to 28 weeks. Since the start of the pandemic, there have been various amendments to the SSP regulations, which is the legislative framework which governs the payment. And those amendments have accounted for things like isolation periods, the earlier payment of SSP in the event of the individual contracting COVID-19, etc. But the general right to pay has not been changed at all. In addition then to that statutory payment, which applies whenever somebody is too poorly to work, some UK employers provide an enhanced sickness payment to their staff, either on a discretionary basis or on a stated contractual one. There's no immediate legal obligation to offer an enhanced company sick pay scheme, but where an employer chooses to do so, then that will likely then create a legal obligation to continue with that offering. Either that will be the case through an express contractual provision. You'll write it into the contracts to say you are entitled to X amount of pounds in the event that you are off sick, in addition to your statutory entitlement, or that legal obligation will be created through custom and practice. So your contracts of employment may be silent, or they may refer to a discretionary benefit, but actually because of the way that you have operated over months, years, and in terms of the payment of that company benefit, you will have indirectly, effectively created a legal obligation on yourself to continue with that benefit through your custom and practice. Now, as with most things employment law related, each case will turn on its own facts when it comes to the question of paying company sick pay for COVID related / vaccine related absence, but employers will need to pay special attention to exactly how they have worded any company pay entitlement in their contractual policy documentation in order to then determine their obligations in the context of what we're talking about today. So with that in mind then, and straight into possibly one of the $64 million questions, what are employees entitled to be paid if they refuse to be vaccinated and then have to self-isolate? So, since the 16th of August last year, fully vaccinated employees do not have to self-isolate at all if they are identified as a close contact of someone with COVID-19. Employees who refuse to be vaccinated are therefore at a greater chance of having to self-isolate because unvaccinated individuals are still liable to an isolation requirement. Employers should pay unvaccinated employees who have to self-isolate as normal if they can undertake their role remotely. Where an employee is unable to carry out their role remotely, however, then the issue of pay becomes a problem. The employee will likely argue that they are willing and able to work and should therefore be paid in full, But the employer's position will be, actually, no, you can't work for health and safety reasons. There's a legal requirement on you to stay at home. There's a legal requirement on you to self-isolate. So no, you can't work. You're not ready and able to work, and therefore I'm not going to pay you. Self-isolating unvaccinated employees without symptoms are entitled to SSP in most cases, but they may not be covered by a company sick pay scheme, depending, as I say, on wording and contractual force, particularly if that scheme is described by the employer as being discretionary. So an example of where an employer would need to pay company sick pay would be where they had a contractual provision to say that company sick pay is payable whenever SSP is payable. That would mean that the same eligibility criteria would apply to both courses of absence and both courses of payment. Here, the employer would have to pay in full where the SSP payment is triggered by self-isolation, whether or not the employee is actually suffering from symptoms or not. Got a question here, Camille. Does that apply across all 4 nations, or is that just in England regarding the isolation regulations? So the content of this webinar is focused on the position in England. I'm not certain what the position is currently in Scotland, Wales, or Ireland, but everything that I'm talking about today is the definitive position currently, because it keeps changing, in respect of England. So just following on from that then, where an employer's contractual provisions, either through the contract or the policy documentation, aren't as strict as that, employers may have a certain amount of freedom to withhold company sick pay from those who are self-isolating, but who have declined the opportunity to be vaccinated. Again, each case will turn on its own facts. And in those cases, there will also be potential discrimination and maybe human rights issues for the employer to consider when they're making a decision about withholding pay. Now, we'll come on to particularly the discrimination issues a little bit later on, but just bear that in mind, that actually, even if your policy provisions aren't as strict as being definitive in terms of when the payment will be made, and it is more discretionary in nature, that doesn't give you the green light just to withhold payment willy-nilly. There will be additional legal considerations to be had in all cases, not just in isolated cases. Where an employee is unable to be vaccinated for medical reasons, or refuses vaccination on, for example, religion and belief grounds, then there is authority to suggest that the employer's inability to work is due to what's known as an unavoidable impediment or an external constraint. And in those cases, the employer should really continue to pay the individual in question. Now, when you're in sort of cases involving unavoidable impediments, again, there might be a sort of a disagreement between the employer and the employee as to whether or not actually the employee's refusals to have the vaccination are reasonable. And I think in those cases, taking some advice is probably your best bet, because like I just mentioned a couple of minutes ago, you're straying then into probably discrimination territory. Medical reasons for refusing vaccines can include things like pregnancy, certain health conditions, certainly religion and belief type refusals are all wrapped up in religion and belief discrimination. So just be really, really mindful again there that if the unavoidable impediment argument comes up, that things may not be as straightforward as they perhaps seem. Irrespective of the legal position, paying only SSP to unvaccinated employees might be controversial from an employee relations perspective. Obviously, that's not a legal consideration. It's a commercial consideration, and each business will have a different view in terms of what is good for their employee relations and what isn't. You might be sat there thinking, well, actually, we've got a workforce that is majority vaccinated, and the unvaccinated cohort are causing problems. So actually, if we implemented a policy to distinguish between vaccinated and unvaccinated in terms of sick pay, that would go down really well. in any event, withholding sick pay from unvaccinated employees is now becoming an increasing in trend across some large organizations, and there's no requirement for you to be of a certain size before you can start thinking about withholding certain payments from unvaccinated employees, as we'll come on to very shortly. If you have a genuine business reason that you can legitimize, then you may very well be in a position to be able to adopt a similar policy to your likes of, like say, Ikea, Wessex Water, etc. Again, we'll talk about that in a little bit more detail as we go on. Moving on then to another key question. Can an employer withhold sick pay from an employee who contracts COVID-19 after refusing to be vaccinated? So here it's slightly different. We were talking about isolation before, and now we're talking about actual contraction of COVID-19. So there's a contraction and the obligation to obviously isolate. I think cutting to the chase on this point, it seems really unlikely at this point that an employer could withhold either statutory or company sick pay from an employee who's refused the vaccine and who has actually contracted COVID-19. The reason for this is because the reason that an employee has become ill and is therefore incapacitated when it comes to work does not affect the basic entitlement to statutory sick pay. Likewise, many company sick pay schemes are likely to have contractual force, and unless the company sick pay scheme distinguishes between different types of illness or the circumstances in which the illness was contracted, then it will be really, really difficult to justify a decision to withhold pay on that basis. So that is something for you to think about if actually what you're wanting to do sort of as a sort of future policy move is to implement something that distinguishes between vaccinated and unvaccinated employees, insofar as actually if you want to make sure that you're protected when employees actually contract COVID-19 and haven't been vaccinated, then you're going to have to actually implement some kind of distinction between the type of illness that the individual has contracted and is suffering from. There's a question. I'll just finish off on this point, and then I'll come on to the question about legitimate reasons for asking colleagues if they're vaccinated or not. It's an interesting one. So when it comes to contractual provisions regarding the limit of employee sick pay to SSP, where their sickness or incapacity is due to their own recklessness or negligence, such as participation in negligent sports, some employers will have that provision in their contracts, and that is entirely reasonable to implement in those cases. However, as things stand when it comes to COVID-19 and to the pandemic, it seems very unlikely that such a clause would sufficiently cover this type of situation. The reason being is that it's a pandemic. It's not somebody who's broken their leg playing football on a Saturday night, or somebody who's broken their arm after having too much to drink on a Friday night, for example. This is a disease that's out there. It's affecting us all. So I think if you are sat there thinking, hey, we're going to be okay because we already have this provision in our contracts that limits the payment of SSP in certain circumstances, that's not going to be sufficient. You are still going to need definitive carve-outs for COVID-19 if you want to be able to limit the payment of any sick pay to individuals because they've contracted the disease. Some employers may express their company sick pay provision as being discretionary. Obviously, in those cases, there is less risk of a successful contractual claim for sick pay if the employer chooses then to withhold it from unvaccinated employees who catch COVID-19. But there might still be discrimination and human rights arguments. I think probably the best policy for you to have, and this might become clear as we talk about, is probably a discretionary scheme, because actually even if you implement a scheme which has a particular carve out for COVID-19, if that ends up in front of a tribunal judge, they may still say, actually that's not particularly fair. Like I just said, then we're in a pandemic, it's affecting everybody, it's a moving target. For you as an employer to just say, right, no company sick pay for anyone who gets COVID, it's not enforceable. That's genuinely a risk. We don't have any case law on the subject at the moment, so we can't say, yes, the courts will decide this way in favour of employers, or they won't. I think the discretionary approach to sick pay is your best. It gives you more flexibility, and it allows you to be perhaps a little bit more flexible in terms of how you justify certain decisions in relation to certain individuals based on the facts that link to their own particular absence. So I think overall, the picture probably looks a little bit grey for employers, with a lot ultimately depending on existing workplace practices. So just focusing some attention on the questions that have come through in the chat then before we move on. So what reasons can we have for legitimately asking colleagues if they are vaccinated or not? I suppose there isn't, the starting point on that is that there isn't a list of questions that employers can refer to and say, right, okay, yeah, we need to know that, we need to know this, we need to know the other. Each case will really depend on why the business believes that it needs to know whether or not its staff are vaccinated or not. Now, in the context of pay, if you have a policy, or if you want to have a policy that makes distinctions on vaccinated staff and non-vaccinated staff, it would be perfectly reasonable for you to ask staff if they're vaccinated or not. Obviously, you can't implement your policy, which you've implemented for business reasons, good business reasons, unless you know what the vaccination status is of staff. So that might be a reason. It might be that you have you work in a high risk environment. You may work in the healthcare sector where obviously separate rules attach. There might be health and safety grounds for you needing to understand if employees have been vaccinated or not. Similarly, you might work with clients who have imposed an obligation on you through the contract that you have with them to be clear on the vaccination status of people who are entering their premises. It's all up for grabs really, but like I say, it depends on what your business reason is for asking about the vaccination status. If that's sound, if you can justify that, if that's reasonable, then you can ask the question. Asking the question about vaccination status is not overly controversial, to be honest with you, because most employers will have a decent enough reason for wanting to understand where their employees kind of are on that. Health and safety is a good argument to have, and it's one that generally overpins everything. What's more difficult is forcing employees to tell you. So if you have somebody who says, well, I don't want to tell you, it's none of my business, then you've got a problem. You either need to accept that and then face the consequences of whatever it is, which could be really difficult. You might not be able to implement policies, like I say, you might not be able to answer your clients' requests in terms of vaccination status, etc., etc. So what you then need to do is start a formal process with the individual, ultimately disciplinary action, I suppose, to kind of, you still can't force them to give the information, but to take action against them, to say why their refusal is so unreasonable that actually it presents a risk for their continued employment. Hopefully you won't ever end up in that position with an employee, because they'll rather tell you about their vaccination status. And to be honest with you, I don't think that there are many people, whether they're vaccinated or unvaccinated, who have a problem with sharing it. It seems to be that both camps are quite happy to share their views. So I don't think you'll find a problem overall in practice. But in any event, whether you ask, whether you don't ask, whether you encounter problems or otherwise, the absolute key point to know is that if you gather that information, you have to hold it in line with GDPR obligations. Information about vaccination status is special category data, so you have to make sure that you have really robust data protection principles in place to protect you against the unauthorized disclosure of that information. So that was quite a long answer to the question about what reasons can you have for legitimately asking colleagues if they're vaccinated or not, but I really, really hope that helped. Okay, so next question. Are you allowed to ask employees to disclose whether they have been vaccinated or not in advance of any decisions around pay? Hopefully I've answered that question in the explanation that I've just given there. Yes, it will be fine for you to ask that, because if you are implementing a policy that creates distinctions on vaccination status, then you will need to understand from your employees where they sit. You can't implement the policy without knowing that information. So yeah, I think you'd be absolutely fine to pose that question in advance of any decisions around pay. Okay, so moving on then. Like I said, in terms of the question about withholding pay, the situation does look arguably a little bit bleak, but all is not lost, because employers can, as we've sort of touched on, move away from existing practices on pay and move to create a distinction between vaccinated and unvaccinated staff through their policy documentation. Now, to date then, only care homes and CQC registered businesses are subject to a legal vaccination mandate. The government is currently considering whether it will still extend this requirement further to the NHS, but it sounds like maybe there's going to be a U-turn made on the original mandate. Who knows? Either way, as things stand, employers in other sectors who want to issue a no job, no jab, or the other way around, no jab, no job type policy will still face significant hurdles and risks, not least those pertaining to the protections afforded to workers by the Equality Act, so discrimination risks. The move by Ikea and others, which didn't amount to a no jab, no job policy, could, however, give employers a little bit of light, maybe at the end of the really dark COVID-19 tunnel, as it might be seen as a way forward for businesses who want to both encourage staff to get vaccinated and who want to have more control over the financial implications of the current isolation rules. So employers who do want to consider adjusting their company sick pay policies in a way reflective of IKEA and others will need to be able, like I said before, to objectively justify and legitimise the proposed change. And when the company sick pay entitlement is contractual, either through express contractual provision, like we say, or through ongoing custom and practice, they will also need to embark upon a process of consultation with the staff in an attempt to obtain their consent to the change. So 2 parts to implementing a policy. 1, an objective justification legitimising the proposed change, and 2, a process of consultation with the affected staff to obtain their consent. They're very, very important. Both of those things of equal importance. If you fail to either legitimise the decision or to consult, then any policy change, any contract change will be unfair. Ultimately, it could be leave you in breach of contract, and it could entitle employees to either resign, or anyone who's dismissed off their failure to give consent sacked. They could give rise to constructive and unfair dismissal claims. Not a position that you want to be in. When it comes to the requirement for objective justification, this will depend entirely upon your business, entirely upon the business rationales in question, and entirely upon your senior management team's thinking behind any decision to implement change. Objective justification isn't always easy, and businesses do need to properly apply their minds to the question of why measures need to be introduced. Objective justification always needs to be tied back to specific business needs and aims, and any attempts at objective justification will fail where a decision is introduced on the basis of a mere preference or of a certain opinion, and there's lots of opinions obviously about vaccination at the current time. Each business will be in a different position, obviously, but where a business has a financially based justification for proposed contractual changes, then they will generally, it is just generally, but they'll generally be in a stronger position to move forward to with consultation with staff than those who don't. So if you are thinking about implementing some changes to your current sick pay schemes to distinguish between vaccinated and unvaccinated people, try and tie it back to a business reason that relates to money. If you can do that, then you're going to be in a decent position, I would thought, to move forward. Being clear, it doesn't matter how good your business case is, you are still not going to be able to implement a blanket no jab, no company sick pay policy. And in looking at creating a two-tier workforce in terms of the sick pay benefit, you will have to include caveats for considerations, including things like medical conditions, religious belief, age, pregnancy, etc. As we know, employees will always be entitled to their statutory payment for any eligible periods of sickness and isolation, and employers can't contract out this obligation. You have no right to do that at all. The only element of pay that you can consider then in any policy is your company payment. I can see a couple of questions come in, but what I'm going to do is just continue with the presentation, because we're going to talk about discrimination risks, and then I'll come back to everything that's in the chat and go through all the questions one by one. So in terms of discrimination risks, then I've mentioned the D word a couple of times. This is a big area for employers to have regard to if they are going to make a decision to take a two-tiered approach to the issue of sick pay in the context of COVID-19 vaccination status. A policy that sees unvaccinated employees lose out on company sick pay, to which they would otherwise have been entitled to had they been vaccinated, is likely to amount to what's known as a provision, criterion or practice, a PCP. Now, PCP might be something that some of you out there have heard of, it's a term that you're familiar with, but essentially a PCP is relevant for the purposes of the Equality Act, the discrimination legislation, when it comes to the question of indirect discrimination. Any provision, criterion or practice, PCP, policy, that could put individuals with a protected characteristic at a particular disadvantage compared with others who do not share that protected characteristic is problematic. Without getting overly technical, this would be contrary to the Equality Act, and it would place you at risk of unlawful indirect discrimination. Now, a vaccination requirement for company sick pay could put employees with one of the following protected characteristics at a particular disadvantage, and there's a few of them. So, age. Now, the government has prioritised, or had certainly prioritised, older individuals for vaccination. Private vaccination is not currently available, and employees outside of priority age groups are ultimately disadvantaged compared with those who are not. In addition, younger employees may be more cautious about being vaccinated due to lower risk of hospitalisation, ICU admission, and also death from COVID-19, given the slightly higher risk of blood clots from the vaccine. So don't dismiss concerns that may arise from younger employees when it comes to not wanting to have the vaccine. The second risk area, disability. Some of the vaccines in production are not suitable for certain individuals with suppressed immune systems. An employee with certain allergies may also be advised against vaccination due to the risk of things like anaphylaxis. Other employees might refuse the vaccination for mental health reasons or due to maybe a phobia of needles. Anything that can be said to relate back to a disability, a health condition that an employee has when it comes to their own personal decision to refuse vaccination status needs to be taken into account when you are looking at the provision of pay. The third risk area, pregnancy or maternity. Current government advice is that pregnant women should be vaccinated, but this wasn't always the case. Previously, the advice was not to. And this change might lead to some pregnant employees to be cautious about getting vaccinated. It's worth noting that indirect discrimination doesn't apply to the protected characteristic of pregnancy and maternity. However, a woman who is disadvantaged by her employer's vaccination pay policy due to pregnancy or maternity could still bring an indirect sex discrimination claim. So you're not entirely out of the woods. Further on the sex protected characteristic of sex, some women might wish to delay the vaccine because they're trying to conceive. That's also relevant. Race, also an area of risk. Vaccine take-up in previous national vaccination programs has been lower in areas with a high proportion of ethnic minorities. Research by SAGE at the back end of 2020 showed marked differences between different ethnic groups in the willingness to take up the COVID-19 vaccination. The greatest hesitancy in minority ethnic groups was due to low confidence in the vaccine, distrust, access barriers, inconvenience, socio-demographics, and a lack of communication from trusted providers. So again, if you're dealing with an employee from an ethnic minority who's got concerns about the vaccine, that's going to be something that you will have to look at when it comes to making a decision about their own individual entitlement to any pay should they choose not to be vaccinated. Religion or belief is an interesting one because this is the category where anti-vaxxers can potentially be afforded protection on the basis of unlawful discrimination. It's possible that under this protected characteristic, certain religious or moral objections could be found to be valid, and therefore employers who force certain policies on their employees in respect of pay then fall foul, like I say, of the discrimination provisions. Also, when it comes to things like gelatin being used in the actual production of vaccines, this might be an issue which concerns Muslim, Hindu, vegan, vegetarian employees, anyone who holds a religious belief that specifically prohibits the ingestion of animal products. That fits in your religion and belief category. Other employees might reject the vaccine because of the embryonic tissue being used to test or develop the vaccine, tying it back to a philosophical or religious belief about abortion, etc. That's covered. Like I say, anti-vaxxers, those are employees who consider that they have a strong belief that vaccines are harmful to public health. Whilst there isn't any specific case law which it definitively addresses the point of anti-vax beliefs, it could pass the relevant legal tests to amount to protected belief under the Equality Act. So something, again, probably that you'd want to take advice on, I think, there, if somebody said that they weren't having the vaccine because they're an anti-vaxxer, and therefore, if you were to withhold their pay, they would seek to bring a discrimination claim against you. Anyway, as you can see, quite a few areas of potential risk there when it comes to discrimination. So going back to a point that I made earlier, employers really do need to ensure that any vaccination requirement attaching to sick pay is justifiable as a proportionate means of achieving a legitimate business aim. Business aims are key, they really, really are. But even where an employer doesn't go as far as introducing such a provision on pay, it should still ensure that its workplace policies don't indirectly discriminate against unvaccinated employees. Just on the point, the reason why I keep talking about indirect discrimination is because a change to sick pay policy would amount to a PCP, which has the effect of putting a certain group at a disadvantage. A policy change on pay will hardly ever amount to direct discrimination, which is one individual or an organisation specifically targeting an individual because of their protected characteristics. So that's why we're talking about this in terms of indirect discrimination. Okay, so let's have a look at some of the questions then that have come through. Oh, I think, is it mostly apologies in the chat? Right, okay. Are you able to decline unvaccinated employees to work from home due to a holiday quarantine? Right, I see. So a travel quarantine. Are you able to decline unvaccinated employees to work from home due to a holiday quarantine? No, I don't think you will be able to. In the event that the individual in question was able to carry out their duties from home, then you would be expected to allow them to work from home. The reason that they are stuck there ultimately is because of a legal requirement for them to remain at home after travel. What you can do is implement a policy to say that if you can't reasonably work from home, and you have to self-isolate, that you will limit any company sick pay attached to that isolation period, that's absolutely fine. But you wouldn't be able to just say, no, because you've been unvaccinated, you can't work from home if you have to stay there because of holiday. That wouldn't be reasonable. Okay, so the next question then.
Yeah, I thought I'd pop in to
Hello,
do my little sort of
hello.
question and answer role.
Thank you,
so
Camille,
much,
because there's quite a few.
Yeah, I expected we get quite a few questions popping in because obviously it is quite a hot topic at the moment.
Yeah, absolutely.
Yeah, we do have a few coming in. If at this point, if people could ask questions in the Q&A area, just so we can keep a handle on it, because obviously in the chat we kind of get other things coming through as well. That would be grand. But we do have a couple of questions. Emma has asked, we have a lot of people in our workforce from different countries who are very against vaccines due to their beliefs, culture, media representation, etc. Would this be defined as a protected characteristic?
Thanks, Emma. It's a really good question. And the answer to it is yes, potentially it would be, yeah. So if an individual holds a certain belief because of their race, culture, etc., then or beliefs, that could fall in the religion belief category, then yes, there's a risk there that the view that they hold about vaccination status would tie back to a protected characteristic, and that therefore they would be protected under the Equality Act in respect of any policy changes that you might make in respect of pay. So what it doesn't mean is that you can't make the changes to your policy. It just means that when you're applying that to that individual, you have to think more widely around whether or not actually it's reasonable for you to implement it in respect of that individual because of their own personal reasons for not having the vaccine.
Okay, thank you very much. Good answer. Yeah, I also have seen a question come in from Andrea, who asks, if changing your sick pay policy, how is the consultation affected by the size of the company? Does that make a difference?
It might make a difference, yeah. So the starting point here is looking at whether or not any company sick pay policy is contractual or non-contractual. If it's non-contractual, so it's not written down anywhere and there's no custom and practice sat behind it, then you wouldn't need to necessarily consult with the staff on a large scale level, because you're not changing policy, you're just you're not changing a contractual provision, you're just updating a policy. If, however, the policy is contractual for whatever reason, then the size of the employer will become hugely relevant. If the proposed change is going to affect fewer than 20 employees, then you'll be able to consult as you would normally, a couple of weeks. If, however, it's going to affect more than 20 employees, then there's a risk that you would then have to follow collective consultation rules. You'd have to go through an election process, etc., and you would have to have a minimum consultation period of 30 days. The reason for that is because, in theory, any potential contractual change can result in an employee being dismissed. Now, where you are looking at potentially the mass dismissal of more than 20 employees, that is when the collective consultation rules come into play. So yes, depending on whether your policy is contractual or not, the size of the company may make a difference.
Okay, very helpful, thank you. Yeah, I've also had a question in. This one's asked, well, basically stated, if we're currently treating employees either with COVID or self-isolating similarly to any other absence of paying SSP, I am assuming we're doing the right thing and won't have any issues. Is that definitely the case?
Yeah, it is. If you only have a policy anyway of paying SSP, and that's what you've been paying to people, whether they've contracted COVID or they're self-isolating because of close contact, whether they're vaccinated or unvaccinated, you are absolutely doing the right thing and there will be no issues there. The biggest risk area is the company sick pay element. If you're making distinctions there, because that's the only area of pay that you can make distinctions in respect of, then you need to have a think about all of these things that we've sort of covered this morning.
Okay, thank you. Sandra's asked, if we have someone who's refusing to come to work due to people testing positive for COVID-19 and they want to work from home, but we need to come in, can we refuse to pay them if they don't comply?
Probably, yeah. You'll need to have a conversation with the employee about why they are so concerned about coming into the workplace, to make sure that there's no sort of underlying discrimination concerns like we've talked about. But if you have proper measures in place within the workplace, health and safety measures to prevent the spread of COVID-19 in the workplace, so you back to your social distancing, hand washing, all that sort of stuff, then yeah, you're absolutely fine to refuse them to pay if they don't come in, because it's a reasonable management instruction ultimately.
Okay, thank you. I've got another question that's come in that's quite intriguing. Someone's asked, what do you think about adding self-isolation periods for those who are unvaccinated to their Bradford factor score?
Whew, that's a really interesting question, actually. My gut, I haven't been asked it before and I haven't even thought about it, but my gut feeling on that would be that you might struggle. I think that would be the sort of overarching, because the self-isolation period is it's mandated by the government. However, what I think you potentially could do is make a distinction between isolation because you've contracted COVID and isolation because you haven't been vaccinated. Because obviously when you're fully vaccinated and you're close contact, you don't have to isolate. It's only if you're unvaccinated. I think some advice around that would definitely be necessary, because any change there would amount to a PCP. So it could potentially place certain groups of people at risk of discrimination. So what you'd need to do is just work out what those potential risk areas are and put measures in place to make sure that any policy kind of didn't expose you unnecessarily. But yeah, really interesting point. I'm going to ask my colleagues about that one. And I'm going to
because I guess the self-isolation is quite different from an actual absence. So it's kind of like a time off, but also, how would that kind of factor in?
I mean,
good pun, Bradford factor in.
My mind's just sort of wearing on that, because a really good question. I really like that.
Yeah, definitely. Thank you to the person who sent that in. I've got a question in the chat from Monica, who basically asks, how do you deal with employees who are too scared to return to work because of COVID risks but don't want to get vaccinated? And then they said the occupational health report doesn't highlight any health issues.
Right, okay, good. So my answer to the first part of that question before the reference to the occupational health report was made was that actually you'll probably need to go and get some occupational health input on this to find out whether or not the individual's reticence to return to work is in relation to ultimately a mental health condition. If the occupational health report is clear, and if you have, a bit like the answer to a couple of questions ago, if you have measures in place within the workplace to ensure all health and safety is met in the context of COVID, then we're back really to this either being a case of an employee refusing to follow reasonable management instruction to come back in the workplace, which is disciplinary, or if the employee is adamant that it is related to a mental health concern or a genuine sort of fear that manifests physically, and there's a doctor's note underpinning that, then we'd be in ill health capability territory. If it was the case that you couldn't sustain the absence any longer. Either way, it doesn't look overly good for the employee if there's no occupational evidence to support the ongoing absence. Certainly.
Cool, thank you very much. Some very, very solid answers.
I hope they're okay. I hope they're making sense.
Yeah, definitely. I mean, for what is quite a complex and evolving topic as well, there's obviously only so much we know at this point. It's been really helpful.
No, I memean, that is a problem, Camille. Like, it is an emerging trend. The tribunals are massively busy and haven't got any case law yet. So we're kind of guessing in some respects as to what actually is going to be reasonable, what isn't. But obviously we've got plenty of fundamental legal kind of principles that we can apply to all of this. But it's just whether or not, given the fact that it's a pandemic, things that end up in front of tribunal judges will be decided maybe more sympathetically.
Yeah, quite possibly. And there's actually a question I thought of during your presentation, which kind of links into that. Just what kind of legal cases are you expecting to see arise in, sort of in response to companies perhaps making moves towards sort of changing their sick pay policy, and similar in terms of vaccination status? Do you think it's going to be mostly discrimination claims, or do you reckon there's going to be any other kind of
It's going to be
discrimination
claims, definitely. Provided that the employer has properly thought about why they want to implement a change to sick pay, then probably sort of unfair dismissal claims, breach of contract claims, they'll be limited. If an employer hasn't properly thought about that and they've just implemented stuff and haven't consulted and all that, then yeah, the risk's going to be there. But this is going to be discrimination, I think. Disability discrimination, because like a couple of these questions have touched on, there seems to be a lot of like mental health issues arising and relating to COVID-19 generally. Obviously, mental health issues can form disabilities under the Equality Act, and if employers are implementing policies or forcing people to come back to work or whatever it is, then that could potentially give rise to a complaint on that basis. But yeah, discrimination claims, I think, are definitely a big one. The other sort of, it's not relevant to sort of what we've been talking about, but the other sort of big area where we're expecting lots of claims is unfair dismissal following furlough. We're waiting for those to come through.
Yeah, no, like you said, it sounds like the tribunals have been kept very busy at the moment.
Yeah. I mean, just on that, the cases that we're having through at the moment, they're being listed for 18 months in advance.
Wow.
In Manchester, we had a case listed for 2024.
Blimey.
So more delayed, yeah.
Right, that is quite a waiting list.
Yeah.
Gosh. Yeah, we actually we've got some question of solidarity going on here. Someone asked in the Q&A if someone else's question had been answered in the chat yet. So sorry if I'd missed this one. It's a question from Sally. I'm not sure if you've already covered it, Charlotte.
No, I don't think I've covered it, but yeah. I do have it right there on my screen.
I'll read it out for a little overview. So Sally has asked, if an employee refuses the vaccination, not for medical or religious beliefs, and it has an impact on them performing in their role, for example, a contract stating overseas travel may be required, but an employee cannot travel due to their vaccination status, can you dismiss them on grounds of being unable to fulfill their job role?
Maybe, yeah. There's no protected characteristic issue, if you like. There's no discrimination issue. If it doesn't tie back to concerns relating to age, race, sex, religion, belief, whatever, then this could certainly end up in a case where the individual's refusals are preventing her from fulfilling her contract, ultimately, and the employer is entitled to address that as a breach, as a disciplinary matter. Each case will turn on its own facts, obviously. And the devil will be in the detail, but yeah, potentially.
Okay, and sorry I missed that question earlier, Sally. Hopefully that's all covered. Awesome. We've got a couple more questions that have come in on the Q&A. Georgia has asked, are we able to ask employees for their PCR results?
Yes. You can ask your employees for their PCR results. You need to know them. If they're saying, I can't come to work or I can come to work. So yeah, absolutely fine. Just going back to the point that I made in the presentation though, test results are sensitive personal data, so you need to make sure that your GDPR policies, your data protection policies, are up to date in terms of storing and using that information.
Yeah. Really good note there, definitely. And someone else has asked, if an employee can no longer fulfill their contract of employment, I think this is quite similar to the last, the one from Sally, actually. So I'm just reading it without sort of reading ahead. So if an employee can no longer fulfill their contract of employment and job role as they're not vaccinated, can this result in dismissal? But I think we've kind of covered that with
it could very well do. It could very well do. Like I say, advice will be needed on cases like that. Look at what's going on and what alternatives the employer might have, whether working from home is possible, etc. But it could result in dismissal.
Yeah. Well, that's all the questions we've had in so far. If anyone else, we've got a few more minutes
Yeah,
in
there's
case
a few
anyone
in the
else wants to
there's a
pop in.
there's a few in the chat actually.
I think it's mostly people saying thanks at this point because they've got to zoom off. I don't think there's any we've missed in the chat. If there is any,
No.
do shout up, people, if we've missed your question. And we do have a little bit of room time wise if anyone else wants to ask something in the Q&A. So I can do a bit of just chatting until then, waffling on. But no, it seems like maybe that's all we've got in at the moment, which lovely bunch of questions. Thank you very much to everyone for taking part in that, and thank you so much, Charlotte, for your knowledge and expertise on what has been a very sort of ongoing, evolving topic. Definitely. I think it's really good to kind of have an overview of these things and sort of just anticipate some of the potential issues that might crop up. Particularly if the employment tribunals are already quite busy. What companies can do to kind of make sure that they're sort of avoiding that area of things. Definitely.
Yeah, definitely. You don't want to be ending up in tribunal anytime soon. Not in the minute.
No, definitely not. Okay.
Thank you. Thank you for having me. Thank you for having me. I hope that I haven't blown everyone's minds with vaccine stuff too early on a Wednesday morning.
It's certainly a complex topic, but no, I think it's been very, very informative and accessible. And I think people are saying thanks in the chat as well. Emma said that was fab. Thank you for the information. Laura says it was very informative. Abigail says, very informative and helpful. Thanks so much for your feedback in the chat, everyone. Everyone's being pretty kind. Which, thank you, Charlotte, for all the fab information. And thanks for your questions. So just to round up, because it doesn't seem like anyone else has got a burning question to ask at this point, we're going to send up a follow-up email of this webinar, including a link to a recorded version. And a few people have asked about maybe having a sort of written version or transcript of some of the questions. We actually have an article we published recently with a few different employment lawyers and HR consultants, including Charlotte here, quoted giving their sort of takes on the current issue of company sick pay and vaccination status. So I can send out a link to that, because that could be quite helpful. Yes, and just on the topic of webinars, just to reiterate that we do have another webinar coming up on the Great Resignation, which is another quite hot topic at the moment. And basically, we're going to have a focus on what small businesses can do in particular to respond to the sort of the wave of resignations or people thinking about changing jobs, and how to turn it into a great retainment instead. So I'm just going to pop a link to that in the chat for anyone who's interested in registering for that next webinar. But in the meantime, I think, we're going to wrap things up just as we come along to 11 o'clock here. So thank you very much, Charlotte. Thank you very much, everyone in the chat and all the attendees. And have a fantastic day and hope to see you soon.